The latest addition to the Irish market is Hogan Lovells. The firm has opened its 17th European office there and will initially focus on financial regulation and antitrust law. This makes it the 12th international law firm to have settled in Ireland since the Brexit referendum. Ashurst announced the opening of its Dublin office just last week. According to press reports, Linklaters already has concrete plans. By the way, you should stay tuned until the end if you don't want to miss anything interesting. And if you don't want to miss anything at all, just subscribe to my channel and don't forget to click the little bell so you get an information when I upload another video. London-based antitrust lawyer Christopher Hutton is the managing partner of Hogan Lovells' new Dublin office. Several antitrust and regulatory lawyers from London office will follow him to Dublin. The Ashurst startup team also consists mainly of antitrust lawyers from London. The head of the global division, Nigel Parr, and the London partner, Ian Burrows, will jointly manage the new location. Like all the other attorneys on the start team, they will split their time between Dublin and London. 11 law firms also based in Germany now have an office in Dublin, including DLA Piper, Clyde & Co., Pinsent & Masons, and Dechert. Since 2017 alone, 12 international law firms have opened an office in the Irish capital. Most recently, it was Denton's in 2020 that founded another location and has since expanded it with several lateral entrants. In order to obtain their EU practice rights, thousands of attorneys licensed in England or Wales had applied for practice certificates with the Law Society of Ireland in recent years, reports the magazine The Lawyer. However, at the end of 2020, the agency ruled that attorneys would not be eligible for an Irish qualification unless they had a physical presence in Ireland and adequate professional indemnity insurance. It is therefore to be expected that more law firms will take the plunge to Ireland, the article continues. The next, and thus the first Magic Circle law firm, could be Linklaters, which, according to press reports, is said to have already secured an office address. Along with Allen & Overy, Freshfields Brookhouse Deringer, Latham & Watkins, Slaughter & May & White and Case, it is one of the law firms in Great Britain with the largest number of lawyers qualified under Irish law, but which does not yet have an office in Ireland. And another thing is, why did Britain and Japan renew their relationship? Global attention is turning to the new Biden administration, particularly references to US policy on issues such as relations with China, the Indo-Pacific, and the four-part security dialogue that has overshadowed some key developments in defense cooperation between the UK and Japan. On February 3rd, the two countries held the fourth meeting of foreign and defense ministers between Japan and the UK after pausing amid UK concerns over Brexit and its aftermath. The 2+2 dialogue, which began in 2015 at a time when Japan took over the rotating leadership of CTF 151 for anti-piracy operations in the Gulf of Aden, defined the ACSA, the Acquisition and Comprehensive Services Agreement, as an important agreement, a pillar in the security cooperation between the two countries. As Foreign Minister Dominic Raab said at the last round, Japan is an important security partner and constant friend of the UK. The United Kingdom, which this year holds the presidency of the group of the 7 large industrialized countries alongside the United Nations Climate Change Conference, has established good contacts with Japan in particular. Japan has become a major hub in Britain's evolving strategy in the Indian and Pacific Oceans. Both sides recently signed an agreement on maritime safety between the Royal Navy and the Japan Maritime Self-Defense Force in order to raise awareness of maritime areas. This follows that the British Army is the only country after the US that trains with Japanese forces on Japanese soil. There is no doubt that both sides moved very quickly to deepen maritime cooperation. In the second round of 2016, the Indo-Pacific region was not mentioned in the joint declaration. Japan only expressed hope that Britain will play a more active and constructive role in the security environment for the Asia-Pacific region and contribute to the peace and stability of the region. By the end of the third round in late 2017, the joint statement had evolved to refer to Japan's initiatives based on a free and open Indo-Pacific strategy and to welcome greater UK engagement in the Indo-Pacific region. This partnership was further strengthened in the recent fourth round, in which the two ministers spoke of making the Indo-Pacific free and open region a reality and their commitment to supporting the international rules-based order. In a veiled reference to common concerns about China, they also mentioned their opposition to attempts to coerce others in the region, including by economic means. After Brexit, Great Britain wants to consolidate its anchors in the Indo-Pacific region again. It is, for example, the return of the prodigal son to a region so familiar after years of uneasy coexistence with continental Europe, a region that is now in apparent chaos. One of the most important results of the fourth round of the 2+2 dialogue is the planned visit of HMS Queen Elizabeth, the largest British warship, together with her carrier strike group to East Asia in order to improve this defense cooperation and contribute to free Indo-Pacific region and an open Indo-Pacific region. This should upset Beijing, which historically criticized the UK for gunboat diplomacy during the Opium Wars of the 19th century, when Britain ruled the high waves from the Suez Canal to Shanghai. The UK also stresses the fact that it may be a dwindling power compared to the height of its colonial glory, but it is certainly not a chase, and it is certainly not an easy task. The dispatch of Britain's best warship to East Asia speaks to a country looking to renew its old partnerships in the Indian and Pacific Oceans to offset the effects of its recent separation from the rest of Europe. There has been a roller coaster ride in relations between Japan and the UK for more than a century. After Commodore Matthew C. Perry forced Japan to sign a trade treaty with the United States in 1854, Japan quickly established a naval partnership with Great Britain, in which most of its large warships were built in British arenas. France also used its vast technological capabilities to assist Japan, but Britain was still the preferred partner. Japan's defeat to China in 1894-1895 made it the preeminent power in Asia and Britain's necessary ally against the backdrop of growing imaginations with China. There is no doubt that Japan's acquisition of the most advanced naval platforms and technologies of the time and the introduction of British operational training units played a significant role in the naval victory over Russia at the 1905 Battle of Tsushima, the first example of an Asian power defeating a European nation. The Anglo-Japanese alliance from 1902 to 1923 continued during World War I, when the Japanese Imperial Navy pursued German warships to aid Britain in the Pacific and Indian Oceans. However, the period before the Second World War caused the two countries to drift apart and ended as opponents in the fighting that raged across Southeast Asia to Kohima in India. It's not surprising that, given their long history of maritime cooperation in the Indo-Pacific region, the UK and Japan will come together again. The UK's call for Japan to join the Five Eyes intelligence alliance could reinforce its tandem with the United States of America, the United Kingdom, Australia, New Zealand, and Canada. An interesting aspect of the Anglo-Japanese alliance in the past is the history of the origins of Japanese curry. Today, the world's only curry festival takes place in Yokosuka, a seaport in Japan that emerged in the history of cooperation between the two countries. It is said that the seamen of the Japanese Imperial Navy suffered from beriberi caused by nutritional deficiencies. The solution that the British Navy apparently proposed was to consume wheat flour rich in vitamins. Their main diet, however, was rice, and Japanese seafarers did not take it lightly for such exotic foods. The British Navy then shared the ubiquitous Indian curry recipe, which is easily available with the chefs on board. The difference was that the sauce was purposely made from a mixture of curry powder and wheat flour. Combined with rice, the Japanese curry, with its juicy ingredients made from meat, poultry, and vegetables, was accepted by the marine classifications and is an instant hit. It has since been at the forefront of popular offerings from Japan. The day the expanded quadruple includes Great Britain is not far away, and curry will appear as the common denominator in naval exercises, especially as it is already very popular in Australia. Perhaps the United States will easily replace hamburgers with curry, knowing how popular it is in the Indo-Pacific. Who knows? And another topic is a serious one. The European Union is set to launch a two-pronged legal assault on the UK in the coming days after the British government's unilateral decision to allow businesses in Northern Ireland more time to adapt to post-Brexit rules. EU 27 ambassadors were briefed on Tuesday on the plans, which are likely to involve initiating a formal infringement proceeding that could end up at the European Court of Justice, the ECJ, and triggering the dispute mechanism in the Brexit withdrawal agreement. The European Commission Vice President Maroš Šefčovič told the ambassadors the plans were still being worked on, but diplomats said on Wednesday there was full agreement at the meeting that the EU had to act firmly, and action could begin as early as this week. To avoid a hard border on the island of Ireland, the Northern Ireland Protocol, part of the withdrawal agreement, requires checks on goods transiting from Britain to Northern Ireland to make sure they comply with the bloc's rules. Some checks have already disrupted supply chains in Northern Ireland, triggering protests from unionist parties, but grace periods, the first of which is due to expire at the end of this month, have so far delayed their full application. The Northern Ireland Secretary Brendan Lewis said last week the UK would unilaterally extend the grace periods, arguing that the government had to act to protect the interests of Northern Ireland and keep shelves stocked. Šefčovič, the EU's co-chair of the Joint Committee overseeing implementation of the withdrawal agreement, subsequently accused the UK of breaching both it and potentially international law, as well as a clear departure from constructive cooperation. The Commission said it had not been informed of the decision in advance of Lewis informing Parliament, and suggested it represented a major blow to trust between the two sides after an already difficult post-Brexit period. As it did last September when the British government introduced the Internal Market Bill, which is said breached the protocol. The EU is now poised to launch a formal infringement proceeding that could ultimately end up before the ECJ, as said. The Commission believes it has established the legal basis for such a step, which would be launched by a formal notice accusing the UK of being in breach of EU law. Britain would have several weeks to respond, but could face sanctions or even fines if it did not comply with an ECJ decision. The Commission is also set to send a second letter, this time to the Joint Committee, accusing the UK of breaching Article 167 of the withdrawal agreement, which requires both parties to consult and act in good faith in implementing it, allowing the treaty's dispute settlement mechanism to be triggered. The EU's expected announcement comes amid mounting frustration at what many see as the confrontational stance adopted by Lord Frost, the former UK Brexit negotiator, who has replaced Michael Gove as the UK's representative on the Joint Committee. Frost did not alert Šefčovič that the UK was planning to announce unilateral action last week, and has also upset the bloc with a Sunday newspaper opinion piece urging it to stop sulking and get over what he called it ill will over the UK's departure. The UK has said the EU was informed at an officials level and denied breaching international law, which is complete bullshit. Sorry for that one, but it is. A UK government spokesperson said, "These measures are lawful and consistent with a progressive and good faith implementation of the protocol." And because that bullshit is still spread in the comments under my videos by Brexiteers. Article 16, once again, is made for emerging emergencies. It is not an emergency in the sense of the protocol if laws are now in place that were known even before the referendum. The UK even was part of writing those rules and laws that are in place now. And it is not there to be triggered in cases of emergencies that were caused because one government did not do their homework and did not implement what they should have done years ago or prepared years ago for January 1st. It is not there for that cause. And so you can cut the crap and you can write it as much as you want, but this is such a bull crap that I'm gonna delete that every time, because this is just another headline propaganda spreading that Brexiteers obviously agreed on at the moment, and I won't have it. It is just bullshit. And Lewis on Wednesday restated in the comments that the action was taken to avoid disruptive cliff edges and insisted the UK remains committed to meeting its international obligations under the treaty. The cliff edges are there because you didn't do your job. His Labour shadow Louise Haigh said the decision to unilaterally extend the grace periods sent a clear message that this government's word cannot be trusted, and suggested the government's Brexit deal always had the potential to unsettle the delicate balance of identities across these islands. And obviously, I don't trust them as far as I can throw them. Concern was echoed by Tory MP Simon Hoare, chair of the Commons Northern Ireland Affairs Select Committee, who said the government didn't reluctantly inherit the protocol, but jointly authored it with the EU. He also warned the unilateral extension of grace periods will have a very destabilizing effect on trust between the UK and both Ireland and the rest of the EU. Lewis is the same minister who admitted in September 2020 that the government planned to potentially override another part of the Brexit deal, a move he said would break international law in a very specific and limited way. Specific and limited way, and they would try that one again now? We'll see. If you want to stay informed, please subscribe to my channel. Auf Wiedersehen.